So I just wanted to make a little video talking about two aspects of social work in private practice that I've encountered, and just sort of explaining my experience. And I prepared this presentation for a Facebook group with other social workers. So there's going to be some things in the slides around asking what other folks would add. When I give that presentation, I'll be sure to include this in the uh, comments down below. So this is the title slide here, Navigating the Legal System. First things first, I just want to say I am compelled to acknowledge that this presentation was created on the ancestral, unceded, traditional territories of the Katzie and Stalo peoples. I thank past, present, and future elders and knowledge keepers, as well as the Métis and Inuit peoples, for safeguarding these lands so that I can work, play, and live as I do. So, a little bit about me. My name is Lorna. I worked in the Ministry of Children and Family Development for 10 years, um, from March 2013 until a couple of months ago. I did the Complex Trauma Master's degree at the Justice Institute of BC in 2019. And immediately after that, I jumped into my MSW and finished that in June of 2021 and got registered as soon as I could in August of that same year. I jumped into private practice February of 2022. And in the process of doing all of this stuff, I had three little kiddos who, based on those years of birth, are 8 years old, about to be 6 years old, and about to be 5 years old. Last but not least, I'm an imperfect human being. I'm trying to learn what I need to learn and unlearn what's not helpful. So I welcome any feedback in that regard. So this presentation is only going to be on what I've experienced, which is going to be a very small slice of the experiences of social workers in general. So please correct me, give me feedback. If you know of any additional resources I haven't included, please provide them, and ask any questions that come up. I think it's important that we collaborate and work together because each of us has a different expertise. And I know that there's things that you all can teach me. So please don't be shy and let me know. So I'm going to jump into the first piece of this, which is documenting disclosures of abuse. Right? When we first meet with clients, this is one of the limits of confidentiality that we talk about. My demographic, the clients that uh, come to see me the most often, are children and their parents who are navigating high conflict separation and divorce. So, based on that demographic, I do get a few disclosures, sometimes weekly. So, what I've learned, and I'm going to be providing the resources that I've read and thought about, is to avoid leading questions, especially when you have a parent who's like, can you ask them about this? Can you tell them about this? Can you use this specific therapy type to elicit an answer from them? And we know that parents are well-meaning. Sometimes, though, it can become apparent that they are trying to vilify the co-parent or limit parenting time with the co-parent. I know most of us will be familiar with parental alienation. I think an important distinction is it's considered alienation when the child is influenced by the primary parent, but it's not considered alienation when there's abuse present. So it would be estrangement. So that's an important distinction I've noticed, especially in the legal system. It's estrangement from the parent when not being near them is warranted, either by abuse, court order, no contact order, or um, any other thing that would lead you to believe the child isn't safe with that parent. And then, yeah, it's alienation if there's no sort of glaring child protection concern. It's just mostly kind of influence of the primary parent against the um, secondary parent. So when a child discloses to you, include their direct quotes as much as possible, using their language as much as possible, because that's something helpful for judges to see. They really see the authenticity of the child's perspective, and that's really our responsibility as social workers to convey in the legal process in whatever way we can. I then make a point of thanking the child for telling me, praising them for their bravery. They may have internalized the idea that telling these things is bad. So I really want to reinforce that this probably took a lot of courage, and so I want to reinforce that telling about these important things is uh, brave and good and something they should do, right? So I usually inform MCFD and then both parents if it's safe to do so. Like if one of the parents is the perpetrator, or that the child is claiming one of the parents is the alleged perpetrator, I have to consider the best interests of my client when I'm receiving that information, right? So I will often consult with my supervisor. I'll bounce ideas off of the call taker because they're generally more familiar with the next steps in the case after the abuse has been documented. So if there's any sort of criminal investigation that's going on, MCFD will already be aware of that and then be able to inform me about my next steps. So when in doubt, ask, right? When in doubt, ask. And then in terms of your documentation, write up that charting entry as if it's going to court. Just write up your charting with the assumption that you will be called to testify about it. This way you've covered all of the elements, that because you can't, once you've been subpoenaed or once you've been asked to come to court, you can't edit that charting entry. You can't go back and change it. So when you're making the original entry, try to include as much detailed information as you can, using the above points that we've talked about. When you call MCFD, it's a long hold time. Sometimes it's been as quick as 5 minutes for me, but sometimes it's been like 2.5 hours. So just budget the amount of time, like maybe inform your partner you're not going to be home for dinner, or, make arrangements to put aside that time and make sure that the disclosure can be reported properly and that you're not feeling rushed. If a client discloses historical abuse to you, so, oh, they're 20 and the abuse happened when they were 3, and they're no longer in contact with the person who abused them, that doesn't represent an imminent child protection concern, but it does need to be documented. So you don't have to call centralized screening. You still can if you feel it appropriate. But if it's historical, you can just chart it, make a detailed charting entry on it, and then you can leave it at that. I'm going to move into the next section of being issued a subpoena, and that's going to be relevant to disclosures and charting entries. So if you have any questions about that, please hold off. And then this part of the slide is for that group that I'm presenting to ask feedback from them if there's anything I've missed or things that they wanted me to include. So, subpoenas. It's terrifying, right? Let's just normalize. It's terrifying for you to be served with court papers, right? Uh, but let's talk about it. Maybe if we can go through the steps of the process. Anyway, these are the steps of the process in British Columbia, and I might not even have gotten that right. So if there's something incorrect, please correct me. I want the correct information to be shared. How I've been served is as follows. So the party who wants to call you to court will either contact you directly or have their lawyer contact you on the phone to confirm your name and address. This is so that they can serve you with the papers. Someone will come to you in person, ask, "Are you?" and then say your name. Once you confirm, they will hand you the paper. Either it's a subpoena or a summons, or it'll show on the piece of paper the nature of what is being requested. If the charting is requested, if the paper says your charting is requested, don't panic, right? You do not have to give over your charting to the process server, so the person who gave you the paper, unless it's a search warrant. A search warrant is immediately give charting, but everything else is not. It's important here to note that it's our duty as social workers to safeguard and protect the confidentiality of our clients whenever possible and to the fullest extent possible. especially when you're working with kids. They can't ever reasonably waive their right to confidentiality. Like, even if a parent said, "Oh, like, do I have permission to look at your chart?" Right? It's not fair to assume that they understand consent. It's not fair to assume that they understand the consequences of releasing those records to either parent, right? So if you do want to resist the release of records, you'll need to consult with your own lawyer and you'll need to prepare an affidavit and submit that to court in advance of the court date. I think up to 2 days in advance. Um, I'll explain a little bit about my case example. For those of you that have BMS insurance, the one that you get hooked up with through the BC Association of Social Workers, they have a legal services option that you can opt into. If you opt into that, you get a legal helpline that you can call 24/7, requesting to consult with a lawyer over the phone. You can send them contracts, you can send them legal documents, and they will review them with you over the phone. I also chose to consult with a local lawyer here in Maple Ridge, and then I submitted my receipt to BMS and they reimbursed me. So it's important to remember that you don't have to shoulder the cost of legal things that are sort of part of the nature of social work. So the case example I have is I was recently subpoenaed by a father of one of my clients who made a disclosure. The father made a request for all of my charting records, but I knew that the only record that was really pertinent was the day that the child made the disclosure. So I responded to the court summons with I need to appear remotely because I wasn't able to go in person on that day, and B, I can only release partially the records. I cannot fully respond to the request because I'm trying to safeguard my client's confidentiality, and I'm trying to only provide the documentation that will be useful in court. The court doesn't have to see all of these different play therapy sessions that I've had with this child because they don't all relate specifically to this matter. So in the end, I didn't have to appear remotely on the day I requested because the judge wasn't available. The date got pushed to a later month. At that time, I was coordinating with both counsels of both co parents, and one of the counsels suggested that should the judge request the unredacted records, that I should bring 4 copies with me to the court appearance. 1 copy for me, 1 copy for the judge, and 1 copy for each party, 4 copies. So I did do that, and it ended up being useful because the judge had said, I won't give as much weight to the social worker's testimony without the context of before the disclosure and after the disclosure in the charting. So after having explained, it's my right to, or it is my duty, sorry, to uphold the confidentiality of my clients, we had the conversation about that, and then I released the records, and I took the stand and spoke about them. So that was my little subpoena experience. I'm going to ask others to sort of recount what happened to them. I'm sure I'm not the only one, and I know this won't be the last time. So that's a little snippet of my court experience. Oh, also, fun fact: I showed up at 9 a.m. prepared to testify at 9:15. Didn't take the stand until 4:15 p.m. So just block off your whole day. If you're called to court, that whole day is gone, basically. So I've got some resources. Well, the one resource I've included here for practitioners is this book that one of my professors actually wrote this, and it's Balancing Conflicting Interests: a Counselor's Guide to the Legal Process. This is the main manual that any social worker, any clinical counselor, any practitioner will want to have in their library. It really breaks down the legal process. It really breaks down giving testimony. It really breaks down all of the different court processes. I've recommended everybody. It's $85, but I think it's a worthy investment. That email was inaccurate, so I've given you the correct email here. I really, really encourage you to get it. And Maureen writes in such a blunt and sort of direct, matter-of-fact style, so it's very accessible. I recommend it to everyone. In terms of clients, there's some really helpful information at protectchildren.ca. This is a website that sort of helps navigate issues of child abuse, child neglect, child sexual trafficking, and things of that nature. So the way that I can, make it safe therapeutically for a child to disclose something is by reading some of these books. And I looked on their website and they have resources all the way from 0 up to grade 12. So I really encourage everyone to check that out. For parents, family.legalaid.bc.ca. You can get this little green book that says living together or living apart. And it really, for people who are uh, considering separation or divorce and want a little bit more information about what it would look like, that's a really helpful little book. Um, for adults in general, both cishet, LGBTQ2S+, and transgendered people. There's more publications specifically for your relationships at that same website. And then anything else that people want to include, I'll throw it in the comments. So yeah, if you have any further questions or want to reach out to me or have a high conflict case that you're thinking maybe you need to refer to me, this is my contact information. Please don't hesitate to reach out. I'm very, very happy to share this information. I think it's helpful for families everywhere to learn what the process is, what options they have, and especially for kids, what options they have. Because depending on which city you're in, sometimes children can have access to their own lawyer for free, which is very empowering for them to have someone go into the court process and represent their wants and their best interests without them having to testify or take the stand. So that is basically it. Thank you very much, both for your attention and if you are a fellow practitioner like me, thank you very much for the good work that you are doing. Let's grow together. Please, again, if you have any other resources that I've missed, let me know. Bring it to my attention. And again, thank you for listening.